Good morning, everyone. Welcome
Morning.
to the weekly Saturday webinar, Knowledge Sharing webinar by Mehta and Mehta. Today's webinar topic is significance of memorandum and article of association. And friends, this topic is very crucial because I'll say it's a starting or a base of a building. So it's a rules, regulations, purpose, the mode and road to achieve that purpose, everything is mentioned there. And accordingly, only company will run. So honestly speaking, many don't give much attention to this document. But when there is a dispute or when there is a JV, this document is of prime importance. Not only that, many times when the corporate action is done, which says that if provided in articles and no one bothers to check that. And that time how it creates a tension and the consequences later on about corporate action. It's people can imagine. I'll give you one example that I was a voluntary liquidator of a company and the company has adopted Article Table A at that time. Table A has provision of qualification of shares. No one checked that. No director, being it's a foreign holding company was in foreign, it was subsidiary in India. So all employees of overseas company and all that were there. No one was interested in the shares. The shares were given to limited people. And the same was noticed. And you can imagine the implications, all the directors who has left also, located at different place, and it was now in a very senior position overseas. So it had a big impact. I'm just giving one example to understand the implications. So how important it is to understand this document, and one has to be very careful. And as a company secretary of a company which want to set up this company, or as a practicing CS, one has to take care. And as an employee CS, you have to always refer and check whether the corporate action is permitted or how you can improve your article. And so this topic is very important. And that's why we have with us a very prominent and experienced CS with us, Mr. Avnish Srivastav. Mr. Avnish is a, thank you, Mr. Avnish, for your time. Welcome to our webinar.
Thank you, ma'am.
Mr. Avnish Srivastav is a company secretary and corporate legal professional by profession with around 20 years of experience in corporate secretarial compliance, corporate law, corporate finance, project finance, debt restructuring, and corporate legal matters. He holds bachelor's degree in law. He is a gold medalist of master degree in finance, postgraduate diploma in business management, and he's a fellow member of our esteemed institute, ICSI. He's working with Garware High Tech Finance Limited, listed company with BSc and NSC as vice president, CS and legal. Before that, he was associated with a company like SR in different vertical. He has worked with real estate, hospitality, infrastructure. He started his career with JK Synthetics Limited. Welcome, Mr. Avnish. And he has contributed research papers in various conferences organized by renowned business schools like IIM, IIT. He is a member of editorial committee of online journal named Scientific Society of Advanced Research and Social Change. Very interesting, Mr. Avnish is actively associated with our institute ICSI and served as a chairman of Navi Mumbai chapter of WRC of ICSI from September 16 to 2018 and is a member of managing committee of CCGRT Navi Mumbai and COE Hyderabad. Very impressed profile, Mr. Avnish. Thanks a lot for your time. Thanks. Our audience will learn a lot from you. As usual, we have with us our other panelist, Mr. Bala. as Professor Balakrishnan generally is a CS having almost 4 decades of experience and worked with Forsico India and regular speaker and regular written article on various topics, especially decided cases under Companies Act. Very rare. And he is the only person who continuously keep on writing articles on decided cases. Welcome, Mr. Bala. We have with us Mr. Sudhakar Sarvatala. Also, is a chief consultant with Mehta and Mehta. He is a member of Institute of CA and member of ICSI and Institute of Chartered Secretary Administrator UK. He has worked as a Vice President, Corporate Secretarial Department for Reliance RIL for 17 years. Welcome, Mr. Sudhakar. Friends, with this, let's discuss on the topic significance of Memorandum and Article of Association. Today's article only is saying that 1.68 lakhs companies were registered in last 11 months in financial year 24. Dominant was service sector, which is 1,12,230. Industries were 34,888 companies, and agriculture and allied industry 10,225. This figure is as of February 24. My dear, 1.68 lakhs company in India in last just 11 months. Imagine the kind of growth and the growth of course, our profession. And don't you think it's apt topic for to discuss today? So I will request Mr. Avnish to say a few words on the topic, then Mr. Sudhakar, and then Mr. Bala. Thanks a lot. Thank you.
Yeah, so we also recognize all our partners. Yeah, Ashwini, Pooja, of course, is going to give a presentation. Alifia, Aditi, and welcome you all. They have a lot of rich experience, and we are going to be sharing a lot of experience also.
Yeah, my mistake. I forgot to introduce my own Pooja Bhagwat. I keep on telling Sujata. I already said that she is the master blaster on the subject. Whosoever in Bombay or out of Bombay knows her. No Mehta and Mehta knows our Pooja. So most prominent personality of our firm is going to do presentation. Thanks a lot, Mr. Alex.
In fact, Deepti, we have a reservoir of knowledge of the people who are in the offing. They are going to address the masterclass in the coming webinars. So this is only a trial part, I think, of that.
Yeah, Mr. Avnish, please.
Yeah, thank you, ma'am. Thank you, sir, for introducing me and Dipti Ben to give you such a say elaborative description of my profile. I think that it's giving me the pressurizing me to justify with the expectation of the audience. But yes, I'll try to cope up with the requirement of the audience, and yeah, I'll try to give the my views on it. So as the Dipti Ben has already set the agenda by giving the words that it is a MOA is the foundation of any building. So it means it is basically the charter document of any company. So every individual means here the meaning is like an entrepreneur who wants to incorporate any company or he wants to start his business. He has to have a legal identity for its company. So it means that the company should have incorporated as a legal entity. And for that, it has a memorandum of association, which will have all the necessary informations which are required to give its a legal entity as an incorporated entity. So what are the main importance of the memorandum of association? Because it is an essential document without which company cannot be registered. Secondly, it works as a guide for all the members of the company, including its director, which includes its objective of the company for which it is incorporated. For all the investors who wants to deal with the company, they also want to know in which company they are going to put the money and what is the kind of business the company is going to do, whether this company is authorized to do such business or not. So that's also become helpful to them to know the objective clause of the company. So basically, there are clauses which deals with the MOA, that is a name clause, which basically deals with the name of the company through which it can be identified, it can be registered as a legal entity. Secondly, the say situation clause, which we know that where the company is going to be registered or where it is going to be registered with in which jurisdiction of the MCA. The third is basically the object clause, that what will be the business of the company for which the company is incorporated, and with what purpose it has been incorporated, and what is the say activities which company can carry out as a business, and that the business is a legal business and it is not conflicting with any act or the public policy. Then the liability is the members' liability is limited by shares, because normally we used to incorporate the companies limited by the guarantee only. Then the subscription clause, who are the main subscriber of the business, and who are the initial subscribers. Here is basically the conflict, and I think is something which has been misunderstood. Then I'll share my the practical experience that sometimes the regulator who are not say MCA but other regulators, who's misunderstood who are the subscriber to the memorandums. They are the only shareholders who will continue to as a shareholder of the company. So sometimes whenever there is a change in the shareholders, then you have to convince to them that the other shareholding can be changed, and then they ask you the certain certification which has to be provided by the certified by the company secretary in practice, or company secretary in the profession, or you can say company secretary in the company, or the practicing chartered accountants, whatever the requirement of that say particular regulator is. So the subscriber of the memorandum are also very important persons, because like I say, those who has conceived the idea to incorporate it, and basically they are the person who is putting the money together to bring it into existence. Then this the first thing comes with that whether these incorporated documents can be changed or not. So the alteration is possible, but yes, again that is subject to the approval of the government, and here the government meaning is the respective RD. In case your company is a listed company, then you have to take a prior approval of the stock exchange wherever it is registered. And then again, it is called in principle approval. And then again, they will ask you that whether the change which is going to happen, versus it is resembling with your, say this object is aligned with the name of the company or not, and how much business is being aligned to the percent in terms of the percentage with the object, with the name of the company, or there is something conflicting clause or not. This is like a restrictive clause in the articles of association, etc. Yes, so there's the essential thing, that is the company has to be incorporated with the words like limited, in case of the private limited as well as the public limited. But in case of the Section 8 companies, it is not essential. If you talk about the articles of association, this is basically the bylaws, basically governing bylaws, which are governed through the charter, governed to the company's management, and it is considered as a charter, which is governing to the internal affairs of the company. So here again, the practical, experience I will say that Diptivan was quoting regarding that whether this clause is incorporated in the article or not. I was dealing with the one cases related with the transparent transmission of the cases where the company has put the certain transfer of the shares on hold. And then the matter went for mediation. There's a mediation center. Then the mediator asked the company that whether this is this is as per the article of association or not. Then the article was referred, and then again there was a power given to the board of directors in case of the dispute come when there is a first holder, second holder, and the case of the first holder dies, and how the shares will be transferred to the successor or not. So then the article was referred, and accordingly the decision was given in that case of the dispute. So obviously it is a charter document which will help you in case of any dispute arises. So it helps to establish a framework for the rules and regulations covering the company's management and operations. So these are the important points which are basically related with the articles and the memorandum of association of the company. And yes, there are cases which we will discuss in between. That how in case of the conflicts, how the cases have been decided by the regulators, considering the provisions which has been incorporated in the article or not. In case of particularly in the case of the joint ventures, because the articles plays a very important role when the private investors are there. I can say there is a joint venture between two particular entities, and there is a conflict. Maybe the joint venture partner wants to take any regulatory action against the other partner. So that time the article is referred. So this is the preliminary view about this article and memorandum of association, and then I'll basically I hand you over to the moderator, and then we will discuss the other case laws in between. Over to you, Dipti Ben.
Yeah, thank you, Mr. Anish. With an elaborate introduction on the topic, people started thinking that they are writing continuously presentation slide is not moving. I said, wait, it is introductory remark. Over to Mr. Sudhakar and then Mr. Bala. Quickly your thing because we are running late now.
Yeah,
Yeah,
correct.
okay, thanks.
See,
And then Pooja can start her present. Thanks.
Hi, good morning, everyone. In fact, okay, that someone asked me that on memorandum articles also you are having a webinar. About 2 days before, I got a call from a very senior company secretary. Say he said there ki memorandum articles everyone knows. I said that is the reason actually why we are holding this webinar, because everyone knows everything, but everyone might not be knowing everything. So sometimes in life, what I felt is that whatever we think this is a trivial issue, and those trivial issues we never focus upon. And if you remember that the first webinar what we have in this masterclass was on definitions. In fact, how many of us have read definitions? And similarly, the same is the case with memorandum of association and articles of association. You ask any senior company secretary also to say the significance of the memorandum articles. I'm sure that he or she definitely will fumble. Let me also admit that to the best of my understanding, I don't think that any forum has organized a program on definitions and significance of memorandum and articles. I'm sure that credit we will only take at Mehta and Mehta. Because the significance of memorandum and articles is very, very relevant for a company secretary and for a director, if not for anyone else. Especially as a company secretary, if you are in service, whenever you join a company, I also always advise that you have to read the memorandum and articles. What a company can do and what a company can't do. If the company can do, how it can do, what are the rules of the game it has to comply with. Several times the company secretaries think that whenever they join, they read the minutes, they read the financial statements, and they start moving on. And some people, they don't even read the past minutes also. The company secretary, the day he starts, he'll think of the board meetings, he will think of the future compliances, whatnot and all. But it is very essential for the company secretary, whenever he joins, he has to read these two important documents based on which the company was allowed to be formed. In addition to that, as a PCS also, whenever you are going to accept a new client, whether it is for secretarial audit or whether it is for advisory services, you have to read these two documents and only after that you have to start the company. But unfortunately or fortunately, just like whenever we appear for exams, though the invigilators repeatedly say that you have to read the whole question paper, we always read half, and whatever the question comes, which we know it very well, we start answering that. In addition to that, I will give only one example and stop it there. In Secretarial Standard 1, we say that a director has a power to ask the company secretary to convene a board meeting. And in the SS1, we say that the company secretary has to take the permission of the chairman, the permission of the managing director, or the permission of the executive director and convene the meeting accordingly. He cannot convene the meeting on his own. And suppose if the chairman says don't convene the meeting, and he has to inform that to the concerned director, and the concerned director have the power to convene the meeting on his own. But if you see the guidance note, it is very clearly we have mentioned that you have to see the articles of association. In the articles, if it mentions that the director, whenever he asks the company secretary to convene the meeting, he is obligated to convene such meeting. Even if the chairman says you cannot convene, but the company secretary is under obligation to convene the meeting as per the articles of association. So there may be several things like this which the company secretary is supposed to do it, because company secretary is not to dance to the tunes of the chairman or the managing director. As a key managerial person, he has his own responsibilities also. So understanding, reading, and studying the memorandum articles significance is very, very important for a company secretary. I will give a pause here and request Bala to take further. And as and when I have to intervene, I will do that. Thank you.
Yeah, we'll do quickly because time will short. Yeah, please.
Good morning to all of you. I have a great pleasure in welcoming you all for this particular session. As looking at the number itself, it shows what is the importance of this particular topic. And enough introduction has been given our panelists and as well as Ms. Sudhakar. So I won't be taking much of a time except sharing only one small example with me, practically. When I actually took up the job as a company secretary, I met one of the stalwart working in a company as a senior company secretary. I met him. So I've been appointed as a company secretary, what I'm supposed to do. He first said, please go take a memorandum article association, go class by class, please understand the thing. First reading is the must. Not only read once, read second time, read third time. This is what he has told me. I said, okay. Within 6 months of time, our company, which was unlisted public company, went to listing. When I went to listing, there are enough number of requirements there in the listing requirement. Then I immediately remembered one of the clauses in our article of association was telling no board meeting can be conducted without the presence of the overseas director, which is a must. As you know, as per the listing agreement, we will have to publish the limited review report every quarterly. And that also within 30 days time. And in a particular quarter, if the overseas gentleman is not available, then company has put into a problem that they will not be able to comply with the requirement of the listing regulations because they will not be able to conduct the meeting, will not be able to publish the limited review report. This was the issue. I remembered this immediately. I pointed out to them, and we also discussed with the SEBI. Then ultimately, the very first and fundamental thing is we altered the articles, saying that for the particular meeting, the overseas director, either he can himself give a waiver or the parent company can give a waiver so that the board meeting can be conducted. Why I'm telling you is, as Dipti has also given an example, and Mr. Sudhakar has also said like that, there are a lot of nitty-gritties like this. If we do not know what is there in the memorandum, what is there in the articles, then we will not be able to interpret correctly. We will not be able to take a right actions. This is what it is required actually. This is what it has happened. So I think today's our presenter is going to take us through the memorandum and article of association class by class. There are various issues. I think we have a expert panelist, Mr. Avnish, who will be sharing his practical experience also on this. Let us have the benefit. Without wasting much of our time, I'll ask Pooja to make a presentation. Over to Pooja, please.
First of all, good morning, panelists and participants. The memorandum and article of association are the preliminary documents that are essential for the incorporation of the company. It defines the company's scope of work, objectives, rules, and internal management. These are the constitutional documents of the company. Hence, and the entire foundation of the company stands upon it. Hence, it is indispensable. These are the public documents, hence can be inspected by anyone internally and externally. For example, before joining any organization, the company secretary or the director or the person who is willing to associate must read the memorandum and article of association. It gives the idea of the nature of business activities and the level of compliance structure of the management. And they can then derive their opinion whether to join, whether to associate or not. The internal management is also have to, before doing any corporate action, they need to understand, they need to read the memorandum and article of association. For example, if the company wants to enter into contract with the government and that clause is not there in the ancillary object, then in that case, the objects to be altered. Similarly, if the company is offering shares to its employees under ESOP, and the article is having entrenchment clause of ROFR, the first refusal right, that clause is, if it is there, then it should be aware that that employee should be aware about it, that he cannot sell the shares prior permission of he has to approach first to the promoters, and then if they refuse, then he can share the shares to the outsiders. Now, these documents are not only in India, in UK, Canada, Ireland, Nepal, and in common law countries, these documents are mandatory documents for setting up of a company. Nowadays, the company's process is online, and hence this memorandum and article of association has to be filed in electronic mode in INC 33 and INC 34 along with SPICE 32. Now comes to Memorandum of Association. It represents the charter of the company. It is one of the constitutional document. It defines the company's relationship with the shareholders, and it lays down the company's objectives in detail and the powers and limitation, and serves as a guide of its operation. Now comes to definition. Memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this act. Some of the salient points: that memorandum defines the limitation on the powers of the company established under the act. It helps to set out the fundamental and essential elements of the company. It allows an investor to know about the nature of business activity before determining his investment. It provides all company information to stakeholders willing to associate with it. Now comes to clauses of memorandum. Memorandum contains name clause, register office clause, object clause, liability clause, and the capital clause. We'll discuss the name clause in detail. This clause specifies the name of the company, and the name should be in the compliance with the provision laid down in the Companies Act and rules. Here we need to follow the Rule 8 of the Incorporation Rules 2014. The points to be considered while applying for a name of the company: it should not be identical or overly similar to the existing company. Here, if the company's name is ABC Contractor and Developers Private Limited, and the proposed name is ABC Developers and Contractor, swapping of the words, that is considered as a similar name. If the singular and plural name, that is Green Technology and Greens Technology, it is also considered as a similar name. If the company is having name that Teamwork Private Limited, then the team.com or team@work private limited, it is also considered as a similar name. The name should be in consonance with the object clause of the company. Suppose the company is having a business of manufacturing of a chemical, and the name contains the construction word, then it will not be allowed by the CRC. The activities, sector-specific activities such as investment, then insurance, then asset management, mutual fund, requires the permission of the sector, that is from RBI, in IRDA and SEBI. Then if you are using the name of the existing trademark, then in that case, NOC from the owner is required. If the trademark owner is a company, then in that case, the NOC should be by way of board resolution, supported by the KYCs of the director. If it is an individual, then the letter format NOC will suffice along with the KYCs of the individual. It should not consider an offense under any law or is undesirable according to central government. For example, the words such as Ashoka Chakra, High Court, Parliament, Central Secretariat are prohibited under the Section 3 of the Names and Emblems Act. And if you want to use that name, then the permission under the Act is necessary. Undesirable names means the words such as Central, Union, Republic, Corporation, Bharat, then Panchayat, Municipal. These words are also prohibited, and for the use of such names, the prior permission of the central government is necessary. If it is a private company, then there should be word private limited at the end of the name. If it is a limited, then limited word should be at the end of the name. However, such provisions, that means such requirements, are exempted for Section 8 companies, because Section 8 companies are generally recognized by the term association, foundation, council, chamber, etc. The applicant has to file the name in SPICE Part A along with the two names in order of preference, business objectives, object code. If it is a company subscriber, then board resolution. If you are using the trademark, then in that case, NOC from the trademark holder has to be submitted. Once the application is filed, the CRC may either reject the application or approve the application. If the name is approved, then it is valid for 20 days and we have to complete the incorporation process within this 20 days. And we have a chance for renewal, that is, this name can be renewed for further 20 days twice. If the name is rejected, then in that case, the applicant has to file the fresh name. If there is any query, then applicant has to comply with the queries and resubmit the form. Then second is the register office of the company. It specifies the name of the state in which the register office of the company is situated. It helps to determine the jurisdiction of register of companies. This is applicable only in case of whether there are two ROC offices in the same state. For example, in the Maharashtra, there are two ROC offices, that is ROC Pune and ROC Mumbai. Similarly, in Tamil Nadu, there is ROC Chennai and the ROC Coimbatore. The company must inform the register office details at the time of incorporation or within 30 days from the date of its incorporation. The register office of is the official office of the company, and therefore all communication, legal notice, documents will be sent to the register office. Earlier, there were many bogus companies incorporated. Hence, MC has introduced new form INC 22. In the INC 22, we need to attach the following documents. That is a certified true copy of board resolution for shifting of register office. Then proof of register office, that is lease agreement, rent agreement, along with the NOC of the owner. If the owner is a company, then NOC by way of board resolution supported by KYC. If owner is a individual, then NOC in the format of letter supported by KYC. Then the copies of utility bills such as electricity bill, telephone bill, mobile bill, gas bill. But here these utility bills should not be older than 2 months. Then this is the additional requirement, that is a photograph of registered office showing external building and inside office along with the director or KMP who has affixed her digital signature to the form. So now to maintain the register office is a duty of the company, because all communication legal notices will be served to the register office of the company. If the ROC sends the notice and it is undelivered, then ROC may issue the show cause notice for the non-maintenance of the register office. And therefore, now this new forms verifies the location and the premises of the register office.
Sorry to interrupt you, Pooja, here. In fact, this form was introduced in the year 2019, because this is again based upon some practical, difficulties when the ROC failed. There was 450 companies, or some odd numbers were, the number of the companies were registered on the same address. Then the ROC was unable to identify that how this building is being occupied by the 400 companies. So then they introduced this, that you have to show the picture of the external buildings, photograph, and then again the internal building, whether you are having at least a desk office there. So that's the kind of cases the precaution has to be taken by you are showing the multiple companies. They say a single address for the multiple companies. So this is basically the form was introduced. You may carry on. Thank you.
Then object clause. This clause states the objectives of the company in detail, and the company has to carry out the business which are mentioned in the object clause, and it helps to protect the interests of the stakeholders, since the company must operate within the scope of its object clause and should not engage in any activities which is not specified in this clause. The objectives can be further divided into two subcategories, that is main objective, which specifies the main clauses, incidental objectives, which specifies the objects which are incidental to the attainment of main objects. In Companies Act 1956, there were three objectives, that is main objects, incidental object, and other object. And the private and the limited companies can do any activity which is mentioned in the other object by complying the provision of section 149(2)(a) subsection 1. In this, the company used to pass the special resolution, then filing of INC 23, and then along with a declaration on the stamp paper saying that the company has complied all the provision of the section 149(2)(a) subsection 1. Now, this provision is not there in Companies Act 2013. Hence, no one can do the business of other objects, even if the other objects are there in their memorandum. In the newly incorporated companies, only main objects and incidental objects are there. So the people cannot do the business of the other objects. Then the liability clause, it specifies the liability of the members when there is a loss or debt incurred by the company. The liability can be limited or unlimited, or limited by shares or guarantee. In case of unlimited company, the liability of the members is unlimited. A company limited by shares, the liability of the members is restricted by the amount unpaid on their shares. Company limited by guarantee, the liability of the members is restricted by the amount each member has agreed to contribute. Now comes to capital clause. The capital clause indicates the authorized capital of the company. It provides the maximum amount of the capital that can be issued to the company stakeholders. It also explains the division of the capital with the number of shares and the face value of per share. It specifies the types of shares, that is equity shares and preference shares. In Companies Act 1956, there was a minimum capital requirement for the incorporation of a company, that is for private and the limited company, 1 lakh and 5 lakh. But now we can incorporate the company with the capital of rupees 100 or 1000 also. But it is advisable that at the initial stage only the company must have the sufficient capital to avoid this process of alteration at the time of expansion. Now the subscription of memorandum. In this clause, we need to mention the list details of the subscriber for subscribers, the names, their address, the number of shares agreed to contribute by them, and therefore these are the first subscriber of the memorandum. And this memorandum of association has to be signed by all the subscribers. If all the subscribers are individual or Indian national, then it has to be signed digitally by all the subscriber. If one of the subscriber is a company or LLP registered in India, and then in that case, it has to be signed by authorized representative or director or designated partner, and he should be duly authorized by board resolution of the said company or LLP. If all the subscribers are foreign national or a foreign company, then in that case, MOA should be signed physically, and it must be signed by subscriber or authorized representative by way of, if the authorized representative is there, then in that case, duly authorized board resolution is required. And this MOA should be MOA along with the incorporation certificate and the board resolution in case of company should be notarized in the country of origin and then apostille. Or you can consolidize these documents by Indian Embassy of the respective country. Then the PDF copy of this memorandum has to be attached in SPICE 32. If the foreign nationals are traveling in India for signing of this memorandum, then in that case, the professional has to give the affidavit saying that the person is having the person is assigned before me, and it has to be supported by the immigration details of that foreign national. And then that affidavit has to be attached along with the memorandum with the SPICE 32. Now, who can be the subscriber? Individuals, foreign citizens, non-resident Indians, minor through natural guardians, any company through a company representative, limited liability partnership through an authorized partner, and any body corporate through its authorized representative. Here, if the director or the subscriber is from land boarding sharing countries, then in that case, prior approval of FIBP is required. Then the minimum subscription. For a one-person company, 1 person is required. For the private company, 2 or more persons. And for the limited company, 7 or more persons or members are required. These are the formats specified in Schedule 1 of the Act. And depending upon the type of company, one should use this format. Table A, it is applicable for the companies having share capital. Table B, for the company limited by guarantee but does not have share capital. Table C, for the company limited by guarantee having share capital. Table D, for the unlimited company does not having share capital. And table E, for the companies, unlimited companies with a share capital. Now comes to alteration of clauses. Section 13 of the Act deals with the alteration of Memorandum of Association. And the memorandum must be altered or amended to include the changes in case of any clause of MOU has been changed. So for all alteration, the standard procedure of passing special resolution has to be carried out. In this, we will discuss this in detail. That's convey the board meeting of the directors for the approval of alteration subject to approval of shareholders, issue notices to the notice of general meeting. EGM notice can be prior 20 days of the EGM. EGM can be held in shorter notice with the permission of at least majority of the numbers and 95% of the paid up share capital of a company, giving a right to vote. Then the notice should be sent to the members, auditors, and directors of the company. The notice must include the day, date, venue details, location, and the agenda of the meeting. Then hold a general meeting. If the quorum is there, then pass the special resolution. Then file MGT 14 along with EMOA and the resolutions notice explanatory statement. The ROC will approve the form and the ROC will scrutinize the special resolution and approve the MOA alteration. Besides this standard procedures, clause-specific procedure needs to be followed. The alteration of name clause. This happens when the company wants to change the name voluntarily due to diversification of the business, or in case of joint venture, or in case of when the RD orders a rectification under section 16. Means if the name is similar or exactly identical with the existing company, or when the trademark holder files an application with the RD, then in that case, for the use of his trademark, that is the trademark, then in that case, RD check all the things, and if it founds that the name is under contravention of the Rule 8 of Companies Act, Companies Rules, Incorporation Rules 2014, then RD orders a rectification, and such orders has to be complied with within 3 months from the date of the order. Now, alteration of name clause. This section 4, 13.2, 13.3, and 116 of the Act provide the alteration of name clause of a memorandum of association. In this, we have to first pass the board resolution, then go for reservation of name in the run web-based form. This name is valid for 60 days. Then after receipt of the name approval, the company has to do the process of standard procedure for passing the special resolution for the change of name. Then filing of MGT 14 and INC 24, along with resolution, explanatory statement, minutes, altered MOA. After approval of INC 24, the ROC will generate a certificate with the altered name, and it will be reflected on the portal.
Here I will add, Pooja, that in case of the listed company, prior approval of the stock exchange is also required.
Yeah. In case of a listed company, prior approval of the stock exchange has to be taken.
Yeah.
Under section 13.2 of the Act, any change in company's name shall take effect only after it is expressly approved by the central government. And such approvals are not necessary in case of conversion of company. That means addition or deletion of the word private or public. That means we do not have to follow this procedure. There is another procedure of a conversion of article, and here we do not have to take the name approval. Alteration of register office. It occurs when the company want to explore the business opportunities in the different state, or whether the company's register office and the corporate office is at a different state, and majority of the compliance and the activities done by the corporate office, then sometimes the management may think that it is easier, or for the smooth operation, we can shift the register office to the corporate office, or to avail the certain exemptions or schemes offered to the corporates by the state government. such as low taxation, low stamp duty, or low administrative cost, like that. In case of shifting of register office, it is not applicable in case of shifting of register within the local limit, within the local limit, that is of the same city. So in that case, only board resolution has to be passed and INC 22 has to be filed. Similarly, in the case of shifting of register office from one city to another city within the same ROC, members resolution is required, then MGT 14 has to be filed and along with the INC 22. In both these cases, there will not be change in the register office clause. The alteration of register office clause is applicable in following cases. In case where there is a shifting of register office from one ROC to another ROC within the same state, or shifting of register office from one state to another state. We'll discuss the procedure of shifting of register office from the jurisdiction of one ROC to another ROC within the same state. Here, the company has to conduct the board meeting, extraordinary general meeting to pass a special resolution for the proposal of shifting of register office from one ROC to the another ROC within the same state. Then, after passing the resolution, company has to file, that standard procedure has to be followed, and the company has to file MGT 14 along with the EMOA within the 30 days of passing resolution. Then INC 23 has to be filed for the approval of regional director. The documents to be filed along with the INC 23, the board resolution, special resolution, with the explanatory statement, copies of minutes, declaration by the key manager person or any two directors, saying that company has not made any default to the payment of workmen or creditors, or had made sufficient provision for the payment of their dues. A declaration has to be given by the officers, authorized officials, as director of the KMP, that the company does not seek change in the jurisdiction of the court in which any prosecution is pending. Then acknowledgement of copy of intimation to Chief Secretary also to be attached. If everything is in order, then RD will pass the order. Then that order has to be filed in INC 28 within 60 days of the RD's order. And after approval of INC 28, the company should file INC 22. This INC 22 will be approved by both the ROC, that the existing ROC and the respective ROC where the change is proposed. And then the new certificate will be generated, confirming the shifting and the new SIN number. In case of company wishes to shift the register office from one state to another, in this case, we have to follow the standard procedure of passing the board meeting and the EGM to pass the special resolution for the shifting of register office from one state to another. Then MGT 14 has to be filed along with EMOA within the 30 days of passing the special resolution. Then the company must send the notices to the creditors and give the advertisement in local language, in the newspaper, in local language and in English newspaper. Then the INC 23 has to be filed for the RD's permission. And this INC 23 has to be filed along with the following documents: the copy of altered MOA, then certified true copy of resolutions with explanatory statement, minutes, power of attorney or board resolution, affidavit verifying no entrenchment of employees, copies of newspaper advertisement, proof of service of application with the chief secretary to the chief secretary, SEBI in case of listed company, or any other sector specific authority. That means if it is an NBFC, then RBI, if it is a IRDA, then if it is an insurance, then IRDA, or if it is a asset management, then the stock exchange. List of creditors, debenture holders along with the auditor certificate. If NOC of the creditors is received, then then certified true copy of notice along with the explanatory statement, proof of service of notice, inviting objection. That means here we need to give the proof of services. That means we have to send the notices to the creditors and debentures, and that proof they require, that receipt they require, postal receipt. Petition with the affidavit verifying the details and various declarations signed by two directors that there is no investigation inquiry pending against the company, correctness of list of creditors, no due statutory dues, and proper newspaper compliance and undertaking from the directors to meet the future debts and liabilities. If there is no objection received, then RD may pass the order. That order again we have to file in INC 28 within the 30 days, within the 60 days, and then after approval we have to file INC 22. Again, it will be approved by existing ROC and the respective ROC of the state. And the certificate will be generated confirming the shifting and with the new SIN number. Here, if any objection received from the creditors, the RD will fix the hearing, hear from both the sides, and then pass the order of shifting. If there is any investigation, inspection or inquiry is pending, then in that case, RD has a right to reject the shifting. Then,
But Mehta, I think Sujata, lot many questions are there. We can take few. The first question is request the panel from Mr. Karthik. Few of will take because many are there. Otherwise, there will be. Throw light on requirement practice on dematerialized clause of private limited company. So you have covered that in the dematerialized.
Demat is coming in the future slides.
Okay, fine.
So I think we won't take the COK, but what we can do is we can take only the MOA related questions.
Yeah. No, it is coming in the next
no,
slide.
no, Demat I have not covered.
So if
Yes.
the
No,
company
not
wants to, if the company wants to demand, there should be provision in article. That is the point.
I think this question is related with the private limited companies. So answer is yes, the private limited company has to amend its article to incorporate it dematerializer clause. That's
Which is
the
compulsory now. That's
yeah.
why.
Yeah.
Yeah, Mr. Karthik, that is the answer, what we were talking, that since now it is compulsory, that require first to amend your article because you cannot demand the security without the provision in the article.
Yes.
Somebody has asked a question, is there any time limit to bring the MOA subscription amount?
180 days.
Can Karta of a HU be a subscriber to a MOA?
What is the question, Bala?
Can a Karta of a HUF be a subscriber to MOA?
He can't be.
If subscribers are body corporate, not being the company under the Companies Act, whether a board resolution will be necessary, or if the board has declared powers to MD, director, etc., can authorize someone to subscribe by way of the authority letter.
Definitely, whoever is the person subscribing to the memorandum, he requires, on behalf of a body corporate, he requires an authorization from the board. In case the board is passing a resolution and giving that authority to a managing director, that in future, he can authorize the people whenever any kind of companies are being formulated. That point of time, the managing director can authorize. Because in case of a group, what happens is that quite number of times we do incorporate subsidiary companies, subsidiary companies mostly. So in such case, every time you cannot go to the board. So that point of time, the managing director, the CFO or company secretary may be authorized to subscribe to the memorandum themselves, or they may authorize in turn somebody else to authorize I may subscribe to the memorandum. It can be done like that.
I think they are asking the body corporate is incorporated outside in their country. There is no provision of board meeting, board resolution in that scenario.
In that case, it is okay.
See, even in case of outside, yeah. Yes, Pooja, please go ahead.
Yeah, in that case, that means that letter will also suffice.
Yeah, we have done this in past.
Yeah, we have done in the past.
Yeah. And
when a startup raises the money, they enter into the shareholders agreement mostly. The shareholder agreement is copied and pasted in AOA by amending it. Why? Importance, any risk if you don't do it.
I think this is a famous decided case. You have taken Sujata letter on that JV agreement or SHA agreement part of Article Y. Basically, it's because of there was one decided case where it happened that there was a separate SHA which has a over restrictive provision than article of association, and the company continued to follow the article, and the same was questioned by the JV partner, And the the court decided that if it is not part of article, it is not binding on this. Article has overriding effect on any other contract. To avoid this non-compliance or misunderstanding, now people just cut paste entire SHA into the article so that it is binding on both the parties. This is the importance.
Primarily, what happens is whenever there is a shareholders agreement, it is between the shareholders only, and company is not a party to that particular agreement. So whenever the shareholders or if anybody is not going as per the terms of the agreement, they cannot make the party as a company because company as a party because company has nothing to do with that agreement. They have to go to the court of law and settle the matter. So for that particular purpose, if the company has to respect the terms of agreement, it has to be made a part of that agreement, or alternately, the terms of shareholders agreement are to be made part of the articles. Say, for example, in the shareholders agreement, you say that the quorum for the board meetings is X.
Yeah.
Or affirmative vote kind of conditions are
Yes.
there. So unless until the terms of the JV agreement are part of the articles, you cannot enforce them. Another question comes whether I need to simply cut paste the JV agreement. No, it is not so. You cannot simply cut paste. One has to apply his mind and he has to see that which are the primary significant conditions of the JV agreement, which are to be part of the articles. Those are to be taken properly to the part of the articles. When you write the agreement, the language is different, and when you put it in the articles, the language is to be different. Ultimately, at the end of the day, what you have to do is whatever the philosophy of the terms of reference of the agreement is properly captured in the articles.
Yeah, there I will mention another case law that was related with the joint venture agreement between the two parties. One was the basically investing company, and second was related with the company which was operating in India and basically having the operation owning the responsibility of the operating that business, and that conflict arises because of reappointment of the managing director. So there was an arbitration clause between the shareholders agreement. And then the other party took the plea that since it is a arbitration clause and it is a private agreement, so they can act on it, and then the matter cannot be referred to the NCLT. But the NCLT decided in your favor because it was related with the operation mismanagement. So they said, though the arbitration clause is there, but it should not be conflicting to the law of the land. This is the
See, forget about the case laws, whatever are there as far as the incorporation of JV agreement conditions and the articles.
Yes.
Question comes, the case laws comes when there is a dispute and you are going to the court of law, then the case law arises.
Yes.
First of all, let us understand that why the shareholder agreement clauses are to be there as part of the articles. If you want that your understanding between the shareholders is to be enforced, unless until they become the part of the articles, they will not get enforced. So that is the primary reason. So as company secretaries, what we have to ensure is whatever the important clauses are there, especially the operational part, that is to be a part of the articles of association. Now, what happens is this case law arises when you are not having that as a part of your articles. Obviously, the company will not allow to enforce those conditions. You have to go to the court, and court ultimately will say the same thing. But since it is not a part of your articles, the company will not enforce it. You go to the court and decide the matter. So it is the responsibility of the company secretaries, especially in case of any kind of JV companies, or if there is any agreements between the, say for example, in case of a private company, there may be some kind of promoter understanding, the shareholders understanding may be there. You have to ensure that it is the part of the articles of association. In case of listed companies, this kind of restrictive clauses are not permitted, but to the extent they are permissible, they may be put in. But in case of unlisted companies, yes, definitely you can have whatever the operating part of the shareholders agreement is there. You have to ensure that is a part of your articles.
In shareholders agreement, at times there is a reverse vesting clause for the shares held by the promoters. Is it legal to do it contractually in SHA and copying the same to AOA?
Reverse vesting means what? Well, I couldn't understand that.
Then we have to ask him only. It's a question raised by Rahul Saria, because he uses the word that there is a tie because of the reversal vesting clause for the shares held by the promoters.
We will take it separately with him. We can now proceed, and if any other question, we can take it.
Whether if a company incorporated with the object of dealing and trading in FMGC products, can the company start the business solar installation supply thereof?
Pooja, you
It is
can.
ultra virus.
No, it's ultra virus, no.
Okay, next.
5th June 2015 notification read with the amendment 13 June 76 said section 1 to section 107 and section 108 shall apply to private company unless specified in respective sections of the articles of the company provide otherwise. Request to panelists to elaborate in this. I think section 108, 1 to 107, 108 is regarding convening and conduct the board meeting
Yeah.
with the
Yeah.
lesser notice, etc. and other thing. Is that correct?
Yes,
Yeah,
sir. Yes, sir. Yes.
Yeah.
So
So he
this,
says this will apply unless specified respective in the articles.
in the section or in the article otherwise?
No, he says this section is
Yeah.
applicable provided unless specified in the respective section of the article of the company provide
I
otherwise.
request, this is,
Ma'am, this is covered by Pooja madam in further slides, entrenchment of articles, so she will cover it in future slides.
okay, fine, yeah.
Okay.
No, Ashwini, it is slightly different. Entrenchment of articles is different to this. Because in case of private companies and closely held companies, they can have more restrictions as far as 101 to 108 are concerned. It is primarily about the sending the notice, about your voting restrictions, the appointing of proxies and all those things. Private companies can have that certain leeways. Okay, that is what is permitted under the Companies Act. So what the notification says is that unless until the articles have certain leave, provided some leeways, those sections will apply to the private companies also intact. That is what this entrenchment is slightly different.
You are right, actually, Sudhakar. If the article provides categorically for those leeway, that would apply. If that article does not provide that, then automatically this section will apply.
Yeah.
You are absolutely right.
Yes.
Can we use the short forms like private company or limited company that is using the word PVT and LTD, etc.? That is another question.
Ashwini has answered no, right, Ashwini? Yeah.
Yes, now it is not allowed.
See, as Pooja rightly said, now it is not permitted, but in the good old days, we used to
Yeah.
have that PVT LTD was permitted. Several times, people, what they used to do is, the certificate of incorporation says XYZ PVT Ltd, but the letterhead used to say XYZ Private Limited.
Yes.
That is wrong. You have to take the name of your company the way it is spelled in the certificate of incorporation.
Yes.
Otherwise, it amounts to misrepresentation. And then okay, by that, it amounts to your non-compliance, your letterheads, your brochures, your other material is printed in a wrong name of the company.
If you have a company with some keyword, which is also a trademark, example, Lovely Innovations Private Limited.
So we need to take the NOC from that trademark holder.
He mentioned that if there is a trademark and registered, you have to take an OC. Yeah. Nice.
Sometime applying the name CRC ask to provide a suffix in the name, and other way they reject the name. Somebody has put it like that.
Because if similar name is there, then in that case, they may ask that to modify the name.
Yeah.
If someone creates the company named Lovely Technologies Private Limited, then what is the remedy? Can we complain with ROC?
We discussed this, no? They require trademark NOC.
Okay. Is it in the same clause of the trademark? Then you need to take NOC that you already put. Actually, Ashwini has already put this here. Actually.
Yeah.
Okay. Form IMC 22. Do we need to attach the photo having the name board of the company outside the office?
Yeah.
Yes, we have
We
to.
need to attach, yeah.
We have to. This
Yeah,
was
that is-
so purpose.
That is required. Not only that, even the photograph, I believe it is to be taken in the particular camera, which is showing the longitude and longitude of the place.
Yes, exactly.
Yeah,
Yes.
Latitude and longitude, we
Yes.
have to give in that form. And
Yeah.
Yeah.
Because when you adjust the photograph itself, that will appear in the longitude and latitude, I believe so.
Yeah.
Yeah. I think Rahul Saria has come back on the reverse
Yeah,
vesting vesting. He says reverse vesting example. Two founders start a company with 50% each. Company rises from the money from the investor and after into a SHA. Reverse vesting clause says that the founder share shall vest in 4 years at 25% each year. If any founder resign or his employment are terminated, only vested share will be considered as a release share and the balance will be restricted shares. The founder will have to transfer back the untested shares. This is very common in SHA startups.
Yeah. See, Bala, if this particular understanding between the shareholders, if you make it as a part of the articles, in case of a private company, it is nothing but a kind of a glorified partnership. So definitely, whatever the understanding is there, if you make it part of the articles of a private limited company or even a closely held public, I think public company, you cannot have this kind of restrictions. Private company, it is permitted. So startup companies, mostly they are private limited companies only. So I think you can put in this clause. There is no issue on that.
It is necessary to have a clause to give the property of the company in the MOA, otherwise it cannot be undertaken such activity. Is it necessary to have the manner in which the transfer will take place? For example, like my first refusal, etc. Otherwise, to open for the shareholder transfer, it's outside us.
Yeah. You want to deviate from or you want to a specific provision, the same need to be provided in article.
It is not first right of refusal for the shares. It seems to be first right of refusal for selling the mobile properties. Am I correct, Bala?
Yeah, that is what
Is
it
it prop-
appears to be from the question.
See, again, the same thing. If it is a private limited, normally these kind of clauses are not there. If it is a shareholders agreement like that, and all, suppose, say, for example, if the private company is having some kind of a assets, and the shareholders who are mostly family members or friends, if they think that if the company is selling any mobile property tomorrow, first of all, it should be offered to the existing
Yeah, promoter
members.
group.
And if it is a part of the article, that is permitted. Absolutely no issue.
Yes.
What is the compliance requirement for using the abbreviation of the holding company name such as?
Just one more minute, Bala. One more minute. I will take it here.
Yeah.
See, whenever any kind of this kind of restrictions, whether the transfer of shares or are concerned, the first right of refusal is to be there to the existing shareholders. In such case, as company secretaries, it is our responsibility to also determine the valuation. How you will value at that point of time, it is to be determined now. Don't determine the what's called as the value of the property and all, but valuation mechanism is to be determined. So, for example, first right of refusal as far as the share transfers are concerned, whether it is at book value, at the face value, or the valuation is to be determined by some registered valuer. Same is the case with the properties also. That is to be also entered into the shareholders agreement as well as into the part of the articles. Then what will happen is that tomorrow, God forbids, if any this kind of situation arises, the implementation will be easier. Otherwise, it will be go to the court of law.
What is the compliance required using the abbreviation of the holding company name such as NSE IFC Limited, subsidiary of NSE? Also, whether object proposed activity is necessary to be part of the name of such cases.
So basically abbreviation of the holding company. So I think the holding company name has abbreviation. We said no, abbreviation is not allowed now.
No, abbreviation of the activities is not allowed.
Ah,
Abbreviation of the name is allowed. That means if the subscriber is the initials of the subscribers, that RK Finance, the subscriber's name is something from the R and K, that abbreviation we can use. But abbreviation of the activities is not allowed now.
Okay,
The
fine.
BSC Limited is there now. The BSC Limited is what Bombay Stock Exchange Limited. Now they are calling it as BSC Limited.
Yes.
There are several companies with that abbreviated names. You can have it.
And what is second question in that?
Also, whether object proposed activity is necessary to be part of the name in such cases.
Name, since it's a subsidiary, whether the object activity should be part of the name. That is the question. Because we always have activity, no?
Because he has quoted the name NSE IFC Limited. So he says NSE
And
IFC.
actually, it's a very specific question, my dear, you have asked. Huh? Yeah, so whether the activities presence is necessary in this name.
See, it is not mandatory. Actually, what is the business of the company? It should be a part of the company's name. So that it is understanding clearly. Say, for example, Apollo Tires Limited means what? It is clear that is a tire manufacturing company. Similarly, Berger Paints India Limited, Asian Paints Limited means what? It is a paint manufacturing company. Unless until that significance of the name it doesn't let. Suppose if you say that, in fact, what the company is. So whenever you are determining company, even ROC will ask you that what for this company is incorporated. The moment that activity of the company is there as a part of the name, the object
Yeah.
of the company should be a part of the name also.
In fact, I'll add further, whenever you're going for the change of the name in case of the listed companies, then again, whenever you have to provide the certificate to the stock exchanges that this proposed activities is aligned with the proposed name of the company and how much activities are related with it. So there's significance is there that there will be correlation between the name as well as the business of the company.
In fact, several times it so happened, especially in the earlier days, this used to be there. Company when incorporated, it was for a particular purpose, especially the dot-com companies used to have earlier in the good olden days. When the dot-com companies got busted completely, they started diversifying into some other activity.
Yes.
So then sometimes they used to change the name of the company, and wherever the companies were not changed, ROC has sent letters to them and asked them to change the name of the company to getting acquainted with the activities of the company.
Yes.
Yeah.
Is borrowing clause in the MOA, AOA is mandatory. If it is not there, can the company not borrow money?
It should be there. It
Out
should be
of
there
one
in the ancillary. It should be there in the ancillary objects of the company, because whenever you are doing any kind of business, ancillary objects is nothing but to furtherance of the business of the company. So in that you have to have clearly about the borrowing and investment clauses are there.
How to amend the previous MOA and the AVA, the new Companies Act? There are limited number of articles in the new version. For example, in the old AOA, we have more than 120 articles, but now it is allowing only 99. How to cater to this problem?
This is rephrasing.
See, to my knowledge, articles are the model articles are to be there. It is not restricting that you cannot have more number of articles. On the lines given in the model articles, you have to phrase your articles. That's it.
Yeah.
In case you change the name of the company, do we have to publish in all the business cards, visiting cards of the employees?
Yes.
Yes.
I don't know what is the publication, because once you name the change, you print the new card.
No.
Might be
He's
asking that.
2 years. That's 2 year criteria, na? That old name and previous name.
Yes.
He is talking about that one.
Okay.
That should be there, not in the visiting cards at least, but in all other company formal
Yeah.
documents like brochures, letterheads. There you have to, not on the visiting cards.
But of course, name of the company, because whom you are representing, obviously it can be misrepresentation.
Why should a confidential SHA be given to the external parties?
It is not
Where it is
SHA. It is your terms of the internal management which you have to make it public, so that outsiders know that what is the way your board meeting is done, what are the rights of the particular shareholder. Yeah, Sudhakar, you wanted to add.
I think
where it is to be given, the confidential agreement, where it is to be given.
Sir, I think his question is related with the voting powers, because sometimes between the shareholders agreement, the voting powers is also determined. So the recent notification which has come, I think that is he is talking about the LODR related regulation, which is not relevant.
Listing regulation. See,
yes,
listing regulation says very clearly that the public should be in sync with your understanding. You cannot have any kind of private understanding in case of listed companies.
Yes.
No, I
That's
think
why
he
it is asking you.
He's also put another question here. I think earlier, in continuation that he is asking, if external parties are asking a AOA copies, is it okay to give a AOA minus the SHA part? I think that was the earlier questions. That is why in continuation with that, he is asking why should we give the SHA to the other parties.
Of course, everyone knows that once it is article, it is complete. You can't.
Yeah, once
See,
it
you
is a
have to
part
give
of the
that-
Public
article,
document.
yeah,
You cannot give extracts of the articles. You have to give the complete articles.
Yes.
how many main activities can be imbibed in the MOA of the company at the time of the incorporation? Can those activities be in the different streams?
Pooja, you want to answer? How many activity to be covered in
See,
object?
how many, again, the same thing. ROC say, objects clause is what? Primarily what the company wants to do. If you say, I will manufacture tires also, I will manufacture pharmaceuticals also, I will manufacture this, I will manufacture that, ROC won't agree with that. That means you have no clarity of your business.
Yes.
So
This
what
is-
primarily you have to do is what for the company is being incorporated. You have to give that as your main objects. What are the ancillaries? Ancillary is nothing but whatever the activities you have to take up in furtherance of the main objects clause that is to be there in the ancillary clauses. Good olden days, we used to have other objects which is not there now under the Companies Act 2013.
Yes.
So there is no question of asking how many objects clause will ROC permits. Earlier days, no doubt about it, we used to have in the main objects clause 3-4 clauses. But to my knowledge, if I am not wrong, ROC as on date is not going to permit you in different objects clause. Pooja, correct me if I am wrong.
Yeah, because nowadays ROC is giving the activity code in the scene number.
Yes.
Specifies the object. So we can't, that means do the multiple objects.
Yes.
Exactly.
Now, alteration of object clause, this, when there is a diversification of the business or the ownership of the company change or joint venture, companies enter into joint venture, or company wants to broaden the existing scope, then in that case, this alteration of object clause done. Under section 39 of the Act, the object clause in the Memorandum of Association can be altered by passing special resolution. And then we have to file the MGT 14 along with EMOA, after approval of which the ROC will register the such change of the certificate and issue the certificate. In case of object clause, we will ROC will issue the certificate thereof. The alteration of capital clause, we can alter the capital clause when we want to increase the authorized share capital or the subdivision of the shares, reclassification, then cancellation of shares or conversion of equity into preference. That time we can alter the object clause. So when the company wants to plan for expansion of the business, or in case of company want to finance the projects, and in that case, the authorized capital has to be increased in order to expand its capacity to issue the additional shares to the existing as well as to the new shareholders. This is generally happens in the case of fundraising. That means company want to raise the funds. Then the subscription, alteration of subscription details. We cannot alter the subscription details of the memorandum throughout the life of the company. Doctrine ultra-virus. Any act beyond the objects is called as ultra-virus to its object clause. A company is not allowed to do any act which is not permitted in its object clause, and therefore an act ultra-virus, its object shall be void and cannot be ratified even if all the members wish to ratify it. This is called the doctrine ultra-virus. This is a standard case of doctrine ultra-virus. The Ashwari Railway Carriage and Iron Company. This main object of this company is to make the sale, lend or hire railway carriage and wagons and all kinds of railway plants, fittings and machineries and rolling stock. These companies entered into a contract with the defendant company Riche to construct the railway line in Belgium. But this clause is not there in the main object. Hence, the court said that this object is beyond the object specified in the Memorandum of Association. Hence, it was held void. And according to court, the phrase to make, sell, lend or hire railway carriages and wagons and all kind of railway plan did not mean the company could build an actual railway line. Thus, the contract was held to be ultra vires. Some of the case laws for non-compliance of this section 4 adjudication orders passed by ROC Calcutta in respect of Regal Resources Limited. In this, the company has been carrying the activities quite some years without having such activities in the Memorandum of Association. Therefore, the company has gone beyond the boundary of its object clause of the memorandum and resulted into ultra vires, and therefore the penal actions taken by the ROC, and the penalty involved is for the company 2 lakhs and for the each director 50,000, that is 1.50, and total penalty is 3.50. In the second case of adjudication by ROC Gujarat, and in case of Alak Brainworks Private Limited, in this case, the company has not the company's altered main object in MOA. Company has altered the main object in MOA and not filed the MGT 14 within the time limit of 30 days. They have filed the MGT 14 after delayed period 20 days, 28 to 80 days, and the penal action, therefore, the penalty levied upon the company is 38,100, and for per director 38,100. The total 1,52,400 is the penalty. The third case of the adjudication order was by the Gujarat ROC for Aegis Life Science Private Limited. In this case, the directors are continuing to operate a partnership firm even after its takeover by a company, since he came to conclusion that it was clearly seen there was a breach of the object, and the penalty involved in this is for the company 5,000, and for the director, for each director 5,000. Then total is a 50,000. So 20,000 is the penalty. Now comes to Article of Association. Article of Association is a rule book of the company. It is the definition. As per Section 25 of the Companies Act 2013, the Article of Association of a company originally framed or altered, applied in pursuance of any previous company law or this act. It is one of the most essential documents of a company. It prescribes the rules and regulation and bylaws according to which the internal matters of the company are conducted. The objectives of the Article of Association. It is a governing document because it establishes the framework of rules and regulation. Legal requirement. It is a mandatory document for registration of a company. Clarity. It gives a vital clarity to the shareholders and directors and officers regarding the prescribed procedure and regulation they must follow while conducting the business activities. It also it gives a protection. It safeguards the interests of shareholders by defining their rights and providing procedure to address the dispute or conflicts. Flexibility. It can be amended over time to accommodate changing circumstances, but provided that the such amendments adhere to the Companies Act 2013 provision. The contents of AOA, extent to which the table A is applicable, different classes of shares and their rights, procedure of issuing share certificates and the share warrants, alteration of share capital, borrowing powers of directors, voting rights of members, payment of dividends and creation of reserves, use of common seal of the company, board meetings and proceedings thereof, accounts and audits, arbitration provisions, and winding up. Now next, signing of AOA. Article has to be signed by all the subscribers as per the procedure mentioned in MOA. Nowadays, the article is online, that means in electronic mode, all the details is are pre-filled, and we have to just sign all the digitally by all the subscribers. Forms of the articles. It is mentioned in the Schedule 1 of the Companies Act 2013. Depending upon the types of companies, we can use the forms of the article. The Table F for the company limited by shares. Table G, company limited by guarantee and having share capital. Table H for the companies limited by guarantee and not having share capital. Table I for the company unlimited company having share capital, and Table J for the unlimited company and not having share capital. Compliance of the AOA with the law. Articles cannot contravene to go outside the jurisdiction of Memorandum of Association, Constitution of India, the public policy, the laws of the land, the Companies Act, and in case of listed companies, SEBI listing regulations to be followed. Now the entrenchment provision in AOA. These provision we can see in the where the company has a joint venture agreement. In that we can see, or it helps to safeguard the interests of minority shareholders. So in that also we can see Section 5(3) of the Companies Act talks about the entrenchment clauses in AOA. Certain provision in Article of Association cannot be altered or amended by simply passing this special resolution, but also require additional procedures. Section 5(4) further mentions that the such entrenchment clauses can be introduced at the time of incorporation or by bringing an amendment later. However, in both the cases, the company must give the notice to the registrar of the companies. The entrenchment clause is for the point of management, it is strict, but for the second view, it creates a safeguard of minority shareholders. For example, if the ABC private company is having 10% stake in XYZ private limited company, and the XYZ private limited company can pass the resolution for the availing bank loans under 80 or for selling of any undertaking, it can pass the resolution without taking the consent of ABC private limited. But if the entrenchment clause would have there, then in that case, all the banks or financial institutions must take the approval of or the consent of the ABC Private Limited for such transfer of undertaking or availing the bank loans under Section 80. This way, it safeguards the interest of the minority shareholders. If the entrenchment clause should be in conformity with the Companies Act 2013. Here, if the clause specifies the reduction of the stay of resident director in India during the financial year from 180 to 120, then it has a overriding effect, and then it is not then such overriding act is a void and not enforceable. Now comes to alteration of Article of Association. Section 13 of the Companies Act states that the Article of Association can be altered at any time by special resolution. However, this power of alteration is subject to restriction. The alteration must be under the provision of the Act. The alteration is subject to conditions stated in MOA. Any alteration that converts public company into private company must be approved by central government. When the alteration of AOA happens, when the company enters into joint ventures and the investor wants to add certain clauses in order to safeguard their interests in case of conversion of public company to private company. This generally, when the company wants to reduce the regulatory compliance and simplify the provision of share transfer and loans to the director, then in that case, they're planning for the conversion of public company into private company. Then in case of conversion of private company into public company, when the company is planning for IPO or expansion of the business. Here, when the company is planning for IPO, then in that case, the company must approve their articles from the stock exchange. Otherwise, stock exchanges will not give the in-principle approvals. Then, to include the addition or deletion necessary, that means as suggested by the management. Steps for altering AOA, we need to pass, that means we need to convey the board meeting and shareholders general meeting to pass the shareholders resolution as per the standard process. This process, again, I have covered. Then alteration in case of conversion of company from private to public. Here, company has to, this process is simplified procedure compared to the conversion of public into private. In this, company has to conduct the board meeting and then extraordinary general meeting for passing the special resolution for the converting of private company into limited company and the alteration of the Memorandum of Association and article. Then Company has to file MGT 14 along with EMOA and EAOA within 30 days of the passing resolution. And then filing of INC 27 with the special resolution explanatory statement within 15 days from the date of passing special resolution for generation of new certificate confirming the said conversion. Alteration in case of conversion of a company from public to private. Here, once again, we have to conduct the board meeting and EGM to pass the shareholders resolution and alteration in the memorandum and article of association. Then filing of MGT 14 with the EMOA and AOA within 30 days from passing of special resolution. Then here we need to file the RD1 within the 60 days from the passing of special resolution, along with the following documents: the copies of memorandum of association with the proposed alteration, minutes.
You can skip this. People can read it.
Achha. Here we need to send the notices to the creditors and debenture holders and advertisement to be done in local as well as English newspaper. Then RD will pass the order and then we have to file that order in INC 28. After approval of the INC 28, then we have to file INC 27. And if any objection is there, then RD has a right to reject the application, or in case of any investigation and inquiry is pending, then in that case, RD will reject the application. Post compliance. The alteration of memorandum articles is to be noted in every copy of MOA and AOA. The penal provision under section 15(2) and section 453. If the company is making default in complying with the provision of subsection 1, the company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every copy of memorandum of articles issued without such alteration. And the punishment for improper use of word limited or private limited, that is, the fine shall not be less than 500 rupees and which may extend to 2,000 rupees for every day for which the name or title has been used. Then comes to doctrine of indoor management. Doctrine of indoor management secures the external environment or outsider against the activities done by the organization. The doctrine states that the people who are dealing with the company to presume that the internal procedures are according to the documents filed with the registrar. Internal matters of a company are not meant for public knowledge, and third party cannot only presume the intention of companies but can't ascertain the information provided to them. Doctrine constructive notice. The process of being aware of public documents is generally referred as a doctrine constructive notice. Doctrine constructive notice states that the company shall deem the party dealing or contracting with which the company to have documents at least be aware of provision. This knowledge is important since the AOA can directly affect the contractual parties of the company. That's it from my side. Thank you.
Yeah, thank you, Pooja. Now, Mr. Bala, we can take the questions.
Yeah.
First, we'll take the question and then allow the participant who raised the hand to speak. So take first question.
Okay. At the time of forming the new private limited company, if one director is a foreign national, then such a director shall sign the MOA through the digitally or physically.
Physically.
Moreover, please let me know what complaints are required under the FEMA.
I think Ashwini has already answered this.
Okay.
Physically and all.
Yes, an affirmation vote required by an investor director on certain board resolutions specified in the AOA would mean enrichment.
Affirmative votes, you can say affirmative clauses permitted. This is not enrichment, I think. Pooja, you may.
What is the question? What it is?
1 minute, huh?
This question.
Yeah, the question is actually saying, does an affirmative vote recorded by an investor director on certain board resolutions specified in the AOA, would it mean enrichment? That is what the question is.
Yeah. It is. Yeah, next.
Can the first director be removed from the articles?
You have answered that.
You have answered.
Okay.
One thing is in this, whenever you are removing the first article, sorry, the director in the first articles, no doubt about it, you can remove it. But you cannot, you don't need to change the articles. In the articles, it will continue, his name will continue to be there. That you don't need to change.
Yeah, that is going to be there because only modification, etc. you change it, but whatever is there, that will still continue to be there. In the AOA of the small company, the meeting to be held in every 3 months is mentioned. But as per the strategy requirement, it can be held twice, that is off calendar year only in the case. What shall prevail, AOA or provision of the law?
So AO is more stringent. That's
So
it.
AOA will prevail because AOA can actually provide the more stringent thing required if the interest of the company. Please specify the provisions of the AOA in which enrichment provisions are applicable.
Which provision is applicable?
Enrichment provision. The question reads like this. Please specify the provisions of AOA for which enrichment provisions are applicable.
I think we have covered in presentation, right? So Pooja has covered the
See,
same.
as I have mentioned that entrenchment means, first of all, one has to understand what is entrenchment. And you are going to entrenchment is any part of the articles. You can bring the stringency that is called as entrenchment. It is not going to be a paragraph or something like that. What is entrenchment?
During the adoption of the article as per the Companies Act 2013, is it mandatory to write the name of the first director or we can write the name of the present director at the time of passing the SR to pass altered AOA?
Got it. What it means.
I'm also not
See,
able
the
to
question
get
is
it
wrong.
actually.
The question is wrong. Actually, when you are incorporating the company in that draft memorandum and articles which you are going to file with the registrar, you have to mention the name of the first directors. So those are the first directors going to be on at the time of incorporation of the company.
No, I think there is something different. I think the question reads like this. During the adoption of the article as per the Companies Act 2013, is it mandatory to write the name of the first director or we can write the name of the present director at the time of passing SR to pass
I think
altered article?
yeah,
That
so
means
he's talking about that post the amendment, the post of this new Companies Act, whenever changes the articles of association, then what has to be mentioned. His question is that is this company is already incorporated under the provisions of 1956, then it is altering the say article of association under provision of 2013. His question that is related.
This
Yeah.
question indirectly asking whether the name of first director
It
mentioned
has to
in article
mention.
can be removed or not. We answered that no.
Yes, yes.
You cannot write the present directors' names. You have to write either you write the first directors or you remove that clause altogether.
Yes.
is MOA the public document? Anyone dealing with the company can access the example, vendor, customer, employee, etc. Yeah, of course.
Yes,
Anybody can take an inspection, can view it, and they can get the certified copies as well. If the subscription amount is to be paid within 180 days, do the company need to issue share certificate within 2 months without receiving money?
Yes. So the shares can be issued only after the subscription money is received.
See, there is always a question comes that subscription money, suppose if the subscriber to the memorandum, you don't pay the subscription money, what will happen?
Yeah, that is the question normally comes.
Okay, so it is
One
actually,
question is already there and he has asked that whether, because without that you cannot commence the business. The one question is already there. So you can answer parallel.
what I'm saying is that certificate of commencement of business was there in the erstwhile 1956 Act. Subsequently, under the Companies Act, though it was there, but subsequently that has been removed. I don't think it is required any certificate of commencement of business, something like that, if I am not wrong. So if there is a dispute between the subscribers to the memorandum after the incorporation of the company, one subscriber says, I don't want to be a subscriber to this thing, and I don't want to pay the money. Because there are one or two company secretaries who have approached me, if this is the situation, what I have to do? What is going to be the answer?
No, of course,
The
you
commencement of business is there. You have to file a form. Commencement of business is there in the new Companies Act.
Yeah, it is there. I
I
think
have-
so.
Suppose if
It
it is
was-
there, Ashwini, I appreciate that. Then suppose if that subscriber is not paying you, he is a foreign fellow, he is an expat. Okay. Now that fellow says, I don't want to be a subscriber to the memorandum and I don't want to pay the money. There is a dispute. What you will do with that?
handle the dispute and has to be taken. We
No,
cannot.
but I think if
Basically-
the commencement is not done within 6 months, ROC will strike off the company. It's a mandatory form to be
Correct.
filed. And the company will
Correct.
be,
Correct.
will not live on for like till the time he pays up.
See, there was a question to me, sir, can we put the money from our pocket? Answer is no, you cannot put the money.
No,
Okay. So in this case, what happened is, Ashwini, as you rightly said, that when you are not able to recover the money from the subscriber to the memorandum, you cannot commence the business. That point of time, you have to allow that ROC to delete the name of the company or whatever the procedure is there.
Yeah.
Yeah.
You have to go visit.
One more thing is that people think that in case of subscribers to the memorandum, you have to allot the shares. In case of subscribers to the memorandum, you don't need to allot the shares because they have already it is an agreement with the company. Only thing is in the first meeting of this thing, if the money has come by then, you can simply note that these are all the subscribers to the memorandum and the following shares have been given to them, and you mention the name of the person, number of shares subscribed, and the distinctive numbers. There is no allotment or pass-through form, again filing and all is not required. Yeah.
CCD must without valuation with the conversion formula based on next round of the funding. Is it allowed under the Act? For example, conversion to be done at 10% discount on the next funding round valuation, which is actually not known today. How to issue CCD in such a case?
Is it a relevant question?
I know this CCD, right? Yeah, take it next. This is not.
Okay. Madam, please let us know the procedure for amendment of the AOE by replacing the old SETA MEA. We are unable to do this AOE and the number of clauses of the AOA are very limited.
What? What it says?
He says, please let us know the procedure for amendment of the AOA by replacing the old set of AOA. We are unable to do it in AOA as the number of clauses in the EAOA are very limited.
So they can get in touch with us, we'll help them.
Okay. If the company director, who is the sole shareholder of the company, is taking management change for his services of the company, this amount is not fixed, but based upon cash profit, can such clause be included in the AYU to allow him to continue getting these management charges? If a company director who is the sole shareholder of the company, he is actually
One minute, stop there. How can be a company owner be the sole shareholder? Even a private company, you have to have two,
at least
It appears to be
the two shareholders. How can he be the sole
1%
shareholder?
company, sir.
1% company, it appears to be.
Pardon?
One
Then you have to
person
say
company.
that, you know. Then you have to say that it is a one-person company. You cannot say a company then.
Go ahead then.
Okay, he is taking a management charges for his services to the company. This amount is not fixed by based upon the cash profit. Can such clause be included in the AOA to allow him to continue getting these management charges?
No answer, Ashwini. The one-person company, he just let him do whatever he wants to do.
In article, you can take a private company and all that. You can.
Or you can do it by a resolution.
Yeah,
Yeah.
resolution or article. Based way is resolution, but still if you want. Yeah,
I think gift we have taken, sir, manner in which the transfer is taking, that also we have discussed.
Paula, before you, when you are searching the articles, let me put one more, two or more conditions, questions of frequently come. Here, of course, they have not come. Number one, do I need to amend my memorandum and articles? Say, for example, in my memorandum, my objects clause is having main objects, ancillaries, and others under the erstwhile Companies Act. So my company was incorporated prior to Companies Act 2013. Do I need to amend my objects clause? Answer is no, you don't need to amend your objects clause. But the only thing is your other objects, whatever were there in the erstwhile Companies Act 1956, by passing a special resolution, you would have taken up that business. Since that kind of provision is not there under the Companies Act 2013, you cannot do anything with your other objects. For all purposes, they are defunct. Number one. So you don't need to amend that. But as and when you are amending your objects clause or any memorandum clause for any purpose in future, it is advisable to amend your objects clause and bring it in parity with the Companies Act 2013. Number two, another frequent question is that common seal is not mandatory now under the Companies Act 2013. But as per my article, still that old common seal clause is continuing. Do I need to affix the common seal? Do I need to comply with that provisions? Answer is yes. If suppose if you don't want to have the common seal, you have to amend your articles and remove that concerned provision, whatever is there in the articles. Otherwise, you have to continue to have the common seal, and whatever the number of directors or the company secretary who is to be there when you are affixing the common seal, that we have to comply with definitely.
But when it comes to the common seal, I actually come to know from the people. Although the company doesn't want to have the common seal, they want to discontinue, but there are many outside agencies, they believe to have the common seal. They are insisting to have the common seal.
Yes, yes.
Especially
correct.
it happens with the government agencies.
Mostly the
mainly,
bankers also.
And also bankers as well.
Bankers,
This is actually a practical difficulty which the people are actually having it, although lawfully we say common seal is not mandatory.
See, that time you have two options. One is continue to have that clause in the articles. Otherwise, go to the court of law and then fight out your legal battle. So better to have a common seal always in your articles and the procedure for affixation of the common seal, because definitely this issue will come with the government agencies because they know the old law only, which was prevailing for 58 years almost. How can you change that?
Yeah, mainly what it happened when you want to sign some contract with the government, especially electricity connection and etc. and other thing, they insist unless you put a common seal, this agreement cannot be executed. That is where we come to. In case of the dormant companies, originally the AOA contained provisions of conducting the board meeting in each quarter, but as the exemptions in the dormant companies under the Act, it is required to have at least 2 meetings. Whether Act will prevail, I think we asked the similar question. If you put in the AOA will prevail.
Yeah, next, yeah.
The commencement of the certificate is not required in the UK Companies Act.
So the solution for that is the moment your company becomes a dormant company, you amend your articles accordingly so that you don't need to comply with that articles provisions. You have to have that 2 meetings only, whatever is required under the Act, amend your articles suitably.
The commencement certificate is not required in the UK Companies Act 2006. India has removed that requirement to have the commencement process to be registered. I think commencement is still there, I think so.
Yeah,
No, it is not there. According to me, it is removed. That's what I said initially.
According to again me, reinstated.
Again reinstated.
Again they reinstated.
Now
What
it is
you are saying
mandatory.
is correct, Sudhakar.
Okay.
What you are saying is absolutely correct. It was actually removed, but
And
it was
10A
again
provision
reinstated.
was brought in. 10A
Yeah.
provision.
Okay, I stand corrected.
When provision of the Companies Act itself mandates the debate to private companies, why company need to alter its MOA? Nothing is provided in the AOA, then can company comply with the provision?
Answered.
This we have answered.
I think we have covered, sir, everything.
Then if covered, then we'll allow the people who raise the hands to speak.
Yeah, I think so.
We covered?
Yeah.
Okay, then we can allow Mr. Karthik. Mr. Karthik, you can speak, unmute and speak, please, if you want.
Good afternoon to one and all. Just a couple of points. I had only put a question on name board photo for INC 22. If you see, this requirement came from 5 years, 5 years back when INC 22A active form was introduced. They said, you know, along with this form, you have to give the photograph of the director standing in a position such that, you know, the name board and all is there. Actually, the notification also did not say that, nor did the form say that. It is only MCA when they did the seminar for us, webinar for us, they shown some photo that, you know, you do it like this. And then it became a tradition or it became a formality that everybody start doing. Today, if you see INC 22, I don't see any requirement that the name board should be there within 30 days of incorporation. You can't expect, you know, companies to design their logo and everything and do it. This was a point I specifically put because there is a confusion prevailing amongst the professionals. Any thought on that?
Mr. Karthik, I think we can, if you have studied the provision, honestly, I don't know, Pooja, you can comment if you want.
It is not mandatory, but ROC is that means.
It is a STP. ROC is not asking anything. And ROC cannot ask anything and everything as per his will and, you know, whims and fancy. Only if there is a provision he can ask. Right?
No, people are following the practice of giving that.
No. This is a problem with people. That, you know, you give more information than what is required, then, you know, it becomes a problem. The practical difficulty is.
Mr. Karthik, have you tried without photographs?
Yes. No, so
And it is done?
I'll tell you. If you see the requirement of the form, it says external. What it means is if there is a big building, you give an external photo of the building, number one, and the director inside the office. That is what the this one says. But our people have started, you know, doing extra compliance and extra interpretation based upon the INC 22A, which was introduced in the year 2019. That is my limited submission.
I mean, put it that way, let the participant have experience of yours that you have done that with the external image and inside the office and it is done.
Yes, absolutely.
So you are giving the message to all our
Yes.
professional colleagues that there is no need of having internal image.
Yes, because even in the active notification also, it was not there. Only MCA at that time had circulated, you know, some message saying that you can do it like this. As a specimen they had shown. I have seen that. I have seen in detail. I have seen that nowhere it is stated that it is required. Why this question becomes relevant is, ma'am, you know me. I am from Bangalore. Here the local requirement now is, you know, we need to have Kannada, this, that, you know, Kannada should be 60% of the name board, so on and so forth. N number of things are there. I can't take a quick position on this. And company has its own logo and things like that. It is not easy. Within 30 days, things are going to happen.
Yeah.
We have no problem in compliance, provided, you know, the provisions are absolutely clear in black and white. And I don't want to assume any provisions also.
Okay. So in short, Mr. Karthik, it is no need to take that with the signboard and name of the company and all that.
Yes.
Only external image and inside the office.
And the logic is also, I'll give you the excellent logic for this. Let us say we are now entering the era of, faceless this thing and all. There are going to be more of, scrutinies and more of inspections going to happen. Let us say one registrar of companies, somebody wants to come to the office of this company. If he knows the external building, it is sufficient for him to come inside. There is no necessity that coming outside my office. See, when I'm in office.
Yeah, so Mr. Karthik, in short that it is no need and you can register. There is no need of doing.
And Karthik, you have done it. You have done it in yourself.
Yeah. He said that he is doing that way only.
Yes.
Okay.
Yes.
Okay. Thanks a lot, Mr. Karthik, for this.
Here I want to correct that. That means I have done one shifting from Maharashtra to Chennai, and in that case, we have to file INC 22, and it will be approved by both the ROCs.
Yes.
So ROC has raised the query that The board is not there. So in that case, I have to attach that
You,
picture of
no,
the
no,
board.
you can explain. Basically, sometimes, many times it happens that even ROC staff does not know these provisions. We have to see, either you deal with them in unofficial manner or you deal with them in the official manner. I prefer to deal with them in the official manner. I carry my book, I take things with me, show my laptop. Where is it written? You tell me. I am willing to do. I am not saying I am not willing to do. But you cannot ask anything of your whims and fancy. That is my limited point.
Yeah, thanks a lot, Mr. Karthik, for bringing.
Second point, also one of the points what I had raised, this is also because there is a lot of confusion in the professional mind. So I thought, this is a forum where, we can share this. This is relating to the 5th June, which also is a question I had put. Okay, 5th June notification. Kindly see that, the old act, we had section 170, which stated that, relating to general meeting, it said that provisions of section 171 to 186, private companies, I am referring to standalone private companies, I am not referring to subsidiary of public company. So standalone private companies can have its own provisions. You can have your own provision as far as so long as you continue to be a standalone private company. Now, this new Act 2013, when it came, it redefined the entire thing, and all the provisions were made uniform for all the companies, be it private companies or public companies. Then this was causing a lot of hardship to all the companies, private companies especially. So then this 5th June 2015 notification came, which stated that Chapter 7, Section 101 to 107 and 109 shall apply. We are talking about general meeting, shall apply unless otherwise specified in the respective sections or the articles of the company provide otherwise. Slightly, they have made a language a little twisted in such a way that this expression respective section is being interpreted as section number 101 to 107 itself. Had it been the position, then there was no need to give the exemption at all. But the fact that they have given the exemption, what it means is respective section here refers to other respective sections of the Act. I'll give example. 61, you want to increase your authorized capital of the company. Section, let us say you can go with the ordinary resolution. Yes, it is a special business. If your article says you don't need an explanatory statement, you don't need a explanatory statement. However, if you go under 68 buyback, or if you go under 62 1C preferential allotment, the section, the rules requires you to give so much of data in the explanatory statement. Even if your AOA says you don't need explanatory statement, you have to give respective section means other respective sections, not this respective section within 101 to 107. This is my humble submission. I thought the panel could have deliberated on that because it directly relates to the articles of the company.
Yeah. Good point, Mr. Karthik, that even though this section which pertains to notice, agenda, explanatory statement, which give liberty to private company to mention otherwise. But if they mention there is a specific section for each corporate action which require a disclosure or particular notice, you cannot breach that act specific provision, and hence you have to comply that. So that will create a kind of a confusion that should be clarified. Mr.
Thank you. Thank you. One more point I wanted to add, in the interest of everyone, now that we have sufficiently discussed this commencement, notification to be given within 6 months, money to receive and all that, does it imply in any way that pre-incorporation contracts cannot be done? If I can't commence the business unless the subscription money is received, does it mean that pre-incorporation contracts cannot be done? Well, if you remember, pre-incorporation contracts were something which was very well discussed academically also during our schooling college CS days, and we used to have it. Does this mean that we can't have a pre-incorporation contract?
Any panelists to answer or discuss?
Maybe Karthik, see what happens is unless until you receive the subscription money, when you say you cannot commence the business, and when you cannot commence the business, how can you what's called as go as per the pre-incorporation contracts? Because if there is a dispute in the compliance of the formative conditions itself, where is the question of that? Because, yeah, Karthik, you raised your hand. You want to say something, I think.
Yeah, sir, I think the idea of commencement of business in this context was to borrow money and to do some such things. It is not a commercial contract. That is my humble submission, sir.
See,
Because
let
there
me
was,
tell you,
we
Karthik,
were,
at one point of time, it was mentioned by somebody, even to open a bank account is also a commencement of business. Somebody says that you not even open a bank account. Technically, I don't know how far it is correct, but
That's
of
not
course, this
correct, sir.
requires
That's not
entirely
correct
different
because unless I open the bank account, I
also.
can't receive the subscription money also. And
I
to,
agree with you. I agree with you. Unless until I open a bank account, how the subscription money will come and all those things. I do appreciate what you say. But actually, what is the question of commencement of business? There is a lot of issues there in that. But one thing is definitely for sure that if the subscription money has not come, when you commence the business, can you honor the incorporation contracts? I have my own doubts about it.
But like in my view, that pre-incorporation contract is entered by the promoter in his capacity till the time for and on behalf of the company to be incorporated. But if till the time the consequences we can take, nowhere it is mentioned that it is not
Correct.
or as such.
correct.
In that case, if the incorporation is not done in his personal capacity, carry on. And if that certificate is not obtained, that person is responsible. Because both the party knows the possibility. It is for the future. They both are knowing that there can be, forget about commencement. There can be situation the company is never incorporated. So in that case, they have to again come back, amend the contract, and it is a contract, Indian Contract Act, how the contract is a very complexity. Or say we can, right, Mr. Karthik, your view? Okay,
I think we can go to other people.
Yeah, Krishnan.
Yes, sir. Good morning. See, actually, I have a doubt regarding this entrancement provisions. Some examples of entrancement related provisions, if it can be given, it will be better in the articles.
See, one of the example is that suppose that the act requires ordinary resolution. You say special resolution. That itself is an entrenchment provision. Entrenchment provisions is what? To bring more stringency on certain important events whenever you want to do it. That is entrenchment.
Okay. Okay, sir. And regarding this doctrine of indoor management and constructive notice, what I understand is there are some exceptions also to that. So if that can be covered, it would be great.
See, primarily doctrine of indoor management means the stakeholders can presume that whatever the internal issues you have to take, so for example, board resolution, shareholders approval, these kind of things, it is presumed that doctrine of indoor management has taken place. The outsiders, they don't have any means to check that whether you have passed the board resolutions, whether you have passed that, filed the particular forms with the ROC or not. So these are all called as doctrine of indoor management, and the outsider, when he is dealing with the company, he can presume that these things have been ensured. Doctrine of constructive notice means that certain things which are there in the public domain, like your articles of association, memorandum of association, which is there in the public domain, those things you have to ensure that the company is having these kind of restrictive powers. That is called a doctrine of constructive notice to the public as such. This is the primary this thing. If you want to understand more, you have to go in deep into that.
Yeah, got it, sir. But my query was mainly regarding the exceptions for this both the doctrines.
That's what I told you that you need to go through the doctrine of indoor management and doctrine of constructive notice. Okay.
Yeah.
So
Okay.
on the these kind of webinars, this is very difficult to explain the everything about that. But I have given the essence of that to you.
Yeah. Okay. Thank you, sir.
Anybody, Mr.
Excuse me.
Sanjeev? Yeah, please. Who's there?
Yeah, good afternoon, ma'am. Yeah, I'm Ajay. Acha,
Yeah.
ma'am, I have a query. I find few companies are still carrying out, article of association which correspondent to, Companies Act 1956. Is it time to change it to 2013 for them?
You would have changed it articles of association long back because there are several areas. Your articles of 56 were contradictory with the Companies Act 2013. I don't know whether you have faced any issue or you are not ensured that compliance with the articles. But if you see the Companies Act 1956 provisions and Companies Act 2013 provisions, there are several areas where your articles of that old act were contradictory. Anyway, that you can examine that and you can please do, because if you see Companies Act 2013, there are several areas. It says that unless until the articles say otherwise, that condition is there. Several areas were there like that. So, in fact, several companies, if I am not wrong, they have amended articles in the inception. I mean, in the beginning itself, 2014 or something like that. If you are not done, if you are not faced any issue so far, it is good. You are not done it, but it is better to amend your articles as of now.
Yeah, you are lucky if you have not faced any problem so far, but it is high time that you should actually alter it now, so that you don't face any problem.
With all due regards, with all due regards, let me also tell you that please examine that whether you have fox passed anyway before the regulator catches you.
Yeah, next, Mr. Sanjeev, I think.
Okay, in the meantime, there is one question has come.
Uh,
I have seen in many articles carrying general powers saying anything can be done by the board, even if it is not specifically provided in the article, but permitted under the act. How far this is correct to have such a general power?
It has no meaning. This sort of article has no meaning at all. Whatever is permitted under the act, anyway, you can do it unless it is restricted by your articles. But saying that, say, for example, that for opening a demat account, you have to have the provision in the articles. For issue of securities, you have to have provision in the article. That kind of thing is there. You have to have it in the articles. You cannot say like a blanket kind of thing like that.
Can casting out to the chairman be considered as a enrichment provision?
I don't think so, because casting provision as such comes only when there is a tie. Otherwise, casting vote has no meaning. That's why, to my knowledge, casting vote doesn't give you any additional advantage. Entrenchment means what? It has to restrict. People should not be able to pass the resolutions just like a jiffy. That is what entrenchment wants to ensure. Casting vote is not an entrenchment provision, according to me.
Please enlighten to get the demat for a state sector companies. In demat is required.
Now state sector companies, see, if they are governed by Companies Act, yes, if there is a sector specific law, and you have to study that applicable law, accordingly it will be. If there is some specific act, you have to go and check everything, and which will prevail, that interpretation is required.
I think that is all in the chat box, but the three
Somebody
people who raised their hand.
Last line is still.
Yeah.
To enforce restriction on transferability of shares in AOA in case of public company when the shares are in demat form. You cannot. You cannot restrict.
You cannot restrict. You cannot restrict.
Is affirmative vote clause where vote of.
One minute. In case of a listed company, you cannot do that. In case of a closely held company, you can always lock in the shares in the demat form. And whenever a share transfer has to take place, you can get it unlocked through the depository and you can do it. So lock-in provision is there for closely held companies and private companies.
Yeah.
That's how you can control the transfers.
Is affirmative clause where vote of investor is required fall within entrenchment?
No, this I think we discussed.
We discussed, yes.
Yeah.
Is an article of permanent directors is still valid?
If it is a listed company, for every 5 years, you have to go back to the shareholders because the listing regulations got amended. Permanent directors is still valid. In case of private companies, closely held public companies, you don't need to go back to the shareholders, but in case of public listed companies, you have to go back to the shareholders once in 5 years.
Then I think we have answered all the questions. Thanks everyone for all your participation. Mr. Karthik, thanks for your extra contribution. Friends, thanks all for raising interesting questions. We have tried to answer all. Thanks a lot. Thank you, Mr. Avnish, for your time and inputs. Thanks, Mr. Sudhakar, Mr. Bala, Pooja, and Ashwini for your contribution. Thank you.
Dipti, before you conclude, our next webinar is going to be on issue of securities on the rights issue on private placement basis. Primarily, it is section 42 and 62 and other relevant laws. So please, your participants maybe attend the webinar next week, duly prepared. Thank you.
There is a request from Mr. Virendra that can we have a session on liquidation winding up? We already have, IBC webinar separately. We have a very good detailed voluntary liquidation webinar also. It is on YouTube, but if time permits, our IBC webinar series is also there. You will get the, notification for the same also. Okay, we are putting on YouTube, our own YouTube.
So they can visit our YouTube channel and you can subscribe, so you can get those regular alerts. So thanks everybody. Thanks Avnish Bhai for your wonderful. Thanks Bala.
So much,
thanks Sudhakar.
Thank you, sir.
And thanks our Pooja for this wonderful presentation and the whole team of Mehta and Mehta. Yeah. Thank you. Thank you very much, sir.
Thanks a lot to everyone. Have a
Thanks
good
a lot.
weekend. We meet next week. Thanks.
Thank you so much.
Thank you, sir. Thank you.